This meeting of the Senate Judiciary Committee will come to order by a term of medieval justice known as the trial by ordeal. Time and again, you have been asked, what is your judicial philosophy? For most of us as elected senators, if people asked, what's your philosophy, we'd point to our voting record. You have a record when it comes to court decisions. And this committee, for the fourth time, is delving into everything that you've published as a judge and even before. So would you like to comment at the outset of those who are looking for a label, what your position is on judicial philosophy?
Yes, thank you, Mr. Chairman. Over the course of my almost decade on the bench, I have developed a methodology that I use in order to ensure that I am ruling impartially and that I am adhering to the limits on my judicial authority. I am acutely aware that as a judge in our system, I have limited power, and I am trying in every case to stay in my lane. In our system, importantly, because judges have limited authority, this is where I'm really observing the constraints on my judicial authority. There are many constraints in our system, importantly, because judges have limited authority. And so I am, first of all, looking at my jurisdiction. Threshold matter in every federal case is to make sure that you even have the power to hear the case. In evaluating jurisdiction, you're looking at all sorts of things, the text of a jurisdictional provision, for example, precedent related to it. If I can get to the merits of the case, if I have jurisdiction, then I am observing the limits on my authority concerning the question. So if it is a statute, for example, or a provision of the Constitution, I'm looking at the text. The adherence to text is a constraint on my authority. I'm trying to figure out what those words mean as they were intended by the people who wrote them.
The senator from Missouri has in his tweets said of your position on this issue,